Major breaking news, the commissioner, which is a glorified law clerk in the Washington Supreme Court, has held a hearing that lasted 57 minutes over whether or not Cowlitz County's decision that magazine bans by the state of Washington violate the Second Amendment, which they most undoubtedly do. Nevertheless, there was an argument in front of this commissioner. We're going to break it down and play you some clips, and we'll see what you think. I don't think you're going to be impressed, but we'll talk about it in a minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books on the Second Amendment and other issues, including Disarmed, what the Ukraine war teaches Americans about the right to bear arms. All right, so major breaking news. As you know, on April 8th, Judge Gary Basher from the Superior Court of Washington State in Cowlitz County issued an injunction and a summary judgment order finding that Washington's ban on magazines that hold more than 10 rounds violated the state constitution as well as the Second Amendment. It was a 55-page powerful ruling in the case of State of Washington versus Gators Custom Firearms, Gators Custom Guns. And well, you may recall the story. Approximately 88 minutes after the issuance of this decision, the Washington Supreme Court, using a designee, a law clerk, if you will, named a commissioner, Michael Johnson, I believe is his name, came out with a stay preventing the effect of Judge Basher's ruling from going into effect, which meant that you had a lawyer commissioner, not a judge, enjoining or staying the decision by a judge, Judge Gary Basher, that had found that the state of Washington's statute banning magazines that held more than 10 rounds to be a fundamental violation of a fundamental individual constitutional right, the right to keep and bear arms. So you have a law clerk essentially, for all intents and purposes, in staying the decision by a judge in Washington State. A lot has been written about this. How is this even possible that a non-judge can override a judge in Washington State? I'll let you guys debate that elsewhere. Nevertheless, yesterday, the commissioner, Michael Johnson, held a hearing, which I will play clips for you down below, and I'll put the entire hearing down below, on whether or not he should reverse his decision that stayed the injunction by Judge Gary Basher. And it's pretty clear after this 57-minute hearing that the Commissioner Johnson is going to rule in favor of the state. He, in my opinion, and you can check it out for yourself, I thought basically for a large percentage of this hearing, the commissioner did a lot of the talking, a lot more of the talking. There's a reason why you're given one mouth and 2 ears, Mr. Johnson, and that's because it's more important to listen than to talk. But apparently this was an elementary school lesson that it seems as if the commissioner may not have gotten that message. Nevertheless, Gator Guns lawyers did the best they could in the time they were allotted, which doesn't seem to be a lot of time. And again, you'll check out the video and see if you agree with my opinion on all of this. Now, the commissioner said he's going to issue a decision about the stay next week. I see no way on earth that the Second Amendment community is going to win this argument about whether or not Judge Basher's ruling should go into effect. I think it's going to remain stayed, which is absolutely terrible. But we're going to talk about some of these arguments that the commissioner raised and the state raised in just one second. Now, I will say that it's pretty clear that the Washington State magazine ban violates the Second Amendment, and I don't know, presumably the Washington State Constitution, if they're similar. Again, all you have to do is violate one, and it's got to be enjoined. But again, if you're in front of really pro-government, anti-gun activists portraying themselves as judges, a form of judicial theater, and that appears to be what we have in the state of Washington. Maybe you'll disagree, but it seems like Washington's judicial system appears to be blending in, as I see it, into like a non-judicial system, where rather than a system of justice out there, you really have a system of non-justice. And you really, in my opinion, from what I can see, it looks like you have a lot of like judicial theater, something I like to say, judicial theater. So it looks as if the arguments are being seriously considered, but at the end of the day, the outcome is predetermined. You'll tell me if you disagree with me in the comments below. But that appears to be that's the impression I'm sort of getting if you look look at the situation. And it's not just the fact that this commissioner in a matter of like 88 minutes was supposedly able to read 55 pages of this powerful decision by Judge Basher, as well as presumably you should read all the legal authorities that go into it and all the information that goes into it, as well as the 30 some odd page brief submitted by the state of Washington. Obviously, the commissioner here must have been a speed reader or something along these lines. It's interesting the commissioner actually seemed to address some of this by saying that he had already gotten up to speed on some of these issues, having been tipped off this case may be coming to him many, many months ago. He indicated that he had been studying to get ready for this, which is kind of interesting. It's almost like he was doing the work ahead of time on the case, trying to figure out how he was going to stay it before the case even got before him. As to whether or not that constitutes prejudging the case, well, I'll let you be the judge of that. Now, let's go into some of the things he said, and then I'll talk about some of the fallacies that he appears to be indicating by the commissioner's comments. To begin with, the first thing to keep in mind is there's no doubt that the Second Amendment protects modern arms. So the first thing to understand is, of course, that the Second Amendment protects modern arms. Here is what the Supreme Court said in Heller. Specifically, the court wrote, quote, "Some have made the argument bordering on frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communications and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding." So right there from the start, the Supreme Court makes it clear, like the rest of the Bill of Rights, that modern technology, modern activities are protected by the United States Constitution. We protect the internet. We protect the phone. We protect radio ads. We protect the television under the First Amendment, even though none of those things existed in the 18th century. It's no different when it comes to firearms. Modern firearms are clearly protected, and that was always understood by the Founding Fathers. And the example I like to give that a lot of people don't remember is that if you look at Article 1 of the United States Constitution, Article 1, that is, Congress's power, it's given the power to create a patent and useful arts department or a patent system to encourage people to go out and invent things. And of course, Thomas Jefferson and Benjamin Franklin, a whole host of the Founding Fathers, were inventors and believed that progress in technology would definitely occur, so much so that the notion of progress in technology was actually written in to the United States Constitution, specifically Article 1 of the United States Constitution, which sets forth the power of Congress to protect patents and other useful arts, i.e. intellectual property. So the Founding Fathers knew that technology was going to advance. It wasn't some speculative thing. It was clearly part of the process of developing the U.S. Constitution. Now let's turn to a couple things the commissioner said. Let's start off with his argument, essentially, and it seems to me that Gator Gunn's attorney was essentially arguing against the commissioner and the state. It looks like the commissioner was almost carrying the water for the state. You can disagree with me, take a look at the film and tell me if you disagree with my opinion, but it seems like he's really arguing on behalf of the state, essentially on behalf of why he stated. So first of all, he talks about why a magazine is not an arm. Because remember, the text of the Second Amendment is the right of the people to keep and bear arms shall not be infringed. He tries to argue that magazines are not arms. Here's what he says.
Yeah, okay. You know, the way I look at a magazine, this is the way I look at it. Okay, as a magazine, yeah, it's an essential component for a semi-automatic weapon for sure. But a semi-automatic weapon works just fine with 5 rounds, or 10 rounds. One of the remarkable statements I saw in a trial court order, and it's really pretty remarkable to me, was it was basically saying that an LCM is functionally identical to a 10-round magazine. Well, yeah, that's kind of true in a sense that they feed rounds into the weapon as the weapon is fired, but the similarity ends at the 11th round. Okay, and in that sense, they're not functionally identical in any way. And then you have magazines that are 100-round capacity. So.
Okay, so this is a typical argument, but it's clearly wrong for a whole host of reasons. First of all, as we've talked about, when you ban, and we're not even going to talk about whether or not a magazine is an arm for a moment. We're going to get to that in one second, but just think about it for a moment. I've explained this to you before. that when you ban magazines that hold more than 10 rounds, you have engaged in banning firearms. You have banned an entire category of firearms, which the Supreme Court has unequivocally said in the Heller case in 2008 you cannot do. Why do I say this? Just think about this intellectually for a moment. If you ban magazines that can hold more than 10 rounds, it means that you have banned an entire category of firearms consisting of those firearms that are capable of firing more than 10 rounds without having to be manually reloaded. So you've essentially banned in the state of Washington all firearms capable of shooting 11 or more rounds without needing to reload. That in and of itself is an entire category of firearms, not just magazines, but firearms that you have banned in the state. So even if you want to play the game that magazines are not arms, which is a stupid argument, we'll get to that in a second, but even if you want to assume that argument is true, which it's not, it doesn't matter because you're still engaging in a firearms ban by banning all firearms in the state of Washington that are capable of holding more than 10 rounds. That is a clear violation of Heller. No ifs, no ands, no buts. So playing games about magazines are not arms, it's cutie, ha ha ha. It might get you some points in a high school debate class, but it has no reality. It's not real. And the U.S. Supreme Court, I can assure you, will not play that kind of a game like you can play. Trust me, the Supreme Court will literally be extremely upset with lawyers that make this kind of an argument. They'll listen, of course, but they're not going to take that kind of argument seriously because magazines are clearly protected by arms. Now, the second point. Let's just talk about magazines themselves. Keep in mind that the U.S. Supreme Court has clearly said over and over and over that things that are necessary components of exercising a right are protected. There's many examples of this, but the example I'll just give right here and right now is we talked about the 1983 decision by the U.S. Supreme Court in the First Amendment context, the free speech, free press context, the Minneapolis Star case. The Minneapolis Star case of 1983 says that ink, hear what I just said? Ink is protected and thus could not be taxed in a targeted way. That was the U.S. Supreme Court 1983 Minneapolis Star. Now, if you go back right now and read the text of the First Amendment, you do not see the word ink, do you? In fact, I don't need ink to exercise my free speech rights because I can go out on a street corner and I can start talking about Joe Biden or Donald Trump or whatever, and I'm allowed to do that, and I don't need to use ink. Right? So the point is that just because there's other ways to exercise your right, the fact is that something is useful for exercising a right, such as ink in the First Amendment context, it's protected. By extension, obviously a magazine can only be used, there's no other purpose for a magazine but to help a firearm function in the modern world, and that's what Judge Gary Basher pointed out, and rightly so. The purpose of the magazine is to hold the ammunition. Now, of course, if you buy into the theory that you can ban a magazine because it's not in and of itself an arm, well, think about the other things that you can ban. You could ban bullets because bullets on their own are not arms in theory, right? They're just sitting there on the table. They don't do anything. Likewise, a trigger, firing pin, barrel. You see what I'm saying? And this is no different than saying, well, we can ban a printing press. Well, because the printing press is not mentioned in the First Amendment, we can ban a printing press. That's absurd. And that's not how the Supreme Court interprets it because, again, anything that can contribute to the advancement or protection or involvement of the constitutional right is necessarily protected. The Supreme Court says this over and over and over again. And by the way, every court that has really looked at this before Bruin, there's some games being played by courts now because they know they're going to be dead in the water under the Heller-Bruin test. But by and large, many courts, including like the United States Court of Appeals for the Third Circuit, and I think even the Ninth Circuit has indicated that things like bullets and magazines are protected arms. They don't think they're protected, but they're viewed as arms. Magazines are indeed arms because they're necessary or help facilitate self-defense. And here's what the Supreme Court said in Bruin about the importance of modern firearms and parts and instruments and things that facilitate armed self-defense. The Supreme Court wrote in Bruin the following: even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments. Listen carefully. That general definition covers modern instruments that facilitate armed self-defense. Period, close quote. Did you hear what I just said? The U.S. Supreme Court signed a Caetano dealing with stun guns says that modern instruments that facilitate, which means help, encourage, make it easier to use, that facilitate armed self-defense are protected by the Second Amendment, signed to stun guns that did not exist in any real respect until the 1970s. Again, that's the Bruen case. So between Heller and Bruen, there's no doubt, and just the logic of banning magazines means you ban a class of firearms in violation of Heller. It's clear that magazines are protected arms undeniably. So let us carry on to the next point that Commissioner Michael Johnson makes in the hearing. And I just bring those points up because the commissioner, which is again a glorified law clerk working for the Washington Supreme Court, makes an observation about how mind-bogglingly different the firearms back when Oregon and Washington were settled, as if that somehow matters for modern firearms. You've just seen the authority I gave you from the U.S. Supreme Court in multiple cases, so it doesn't matter that modern firearms are different than old-fashioned firearms, although I would submit that I would rather be shot by a 5.56 round than a 50 caliber musket ball. That's a pretty big round to get hit with. That doesn't seem like that would have been fun in the 18th century, but I digress. The point is that it is borderline frivolous, as the Supreme Court has said, as I pointed up above, to indicate that modern firearms are not protected. It doesn't matter about what kind of technology existed at the time of the founding anymore. It doesn't matter whether or not you had the internet, the telephone, the radio, or the television, or any of these things at the time of the founding. It's totally irrelevant. In fact, the Commissioner Johnson should be aware that the U.S. Supreme Court has literally called that kind of analysis that he was engaging in as borderline frivolous. Bordering on the frivolous is what the Supreme Court says. Commissioner Johnson should take note. Here is what Commissioner Johnson said about how weapons are different today than they were when Oregon and Washington was being settled. Check out this clip here.
It's just, we talk about the arms that they had then compared to the arms that we have today. It's just mind-boggling, the technological difference. And then even in Washington 30 years later, one of the passages in Oregon is, the arms that the settlers had for their personal defense and also for military purposes. Washington in 1889, all of the difficulties, all the tragic difficulties with the native population had long been settled. And we had a National Guard. It was real tiny, and so the point I'm making is that, talking about what people had back in those days compared to what they have now it's mind-boggling, the technological difference. But you go ahead, all right?
Yes, Your Honor. And on that point, Heller, McDonald, and other cases make clear that the firearms, the right to bear arms, isn't locked into that type of technology that was available when the right was enshrined, similar to the First Amendment, which the Second Amendment is subject to the same rights and protections, or contours and protections, etc.
The third thing that the commissioner said that was really off the rails, in my opinion, is he engaged in blatant interest balancing because he talks about mass shootings. Here's the clip right here where he's discussing something he really should not be talking about in this Second Amendment context. Let's go to the tape.
Here's something that's not speculative, okay? Here's something that's not speculative, is that the representatives, the legislators acting as representatives of the people, the elected representative people, enacted this legislation for the purpose of easing people's minds about the danger of a mass shooting happening, where the shooter has, for example, as happened in Las Vegas, has happened in the Aurora theater shooting and that type of thing, has maybe like 100-round magazine and is going out there and just slaughtering people, and can keep doing it until they have a chance to reload, until they have to reload, okay? And so I think you would certainly agree that a shooter with a 10-round magazine has got to reload more often than somebody with a 30, a 50, or a 100-round magazine. Is that correct? I mean, they have to pause and reload. Is that correct?
Yes, Your Honor, and I think that's exactly why LCMs facilitate effective self-defense as well. Let's say that Your Honor was in your home at 3 a.m. Some of these crazies who have been calling you recently about this decision are, they show up and they're armed and they're going to knock down your door. I venture to guess that the court would rather have a 30-round magazine than a 7-round magazine.
No, I wouldn't. I wouldn't. You know what I would do? You know what I would have? Here's what I would have. Okay, if somebody went and knocked down my door, I'd have an M1911A1 like my dad had from World War II, because it's got a nice big round thing, and it'll or a 12 gauge shotgun, which might have 4 or 5 rounds. Come on. I don't buy this idea that you need to have, an AR-15 or a Glock or something with 15 or 30 or whatever rounds. I know shooting. I'm familiar with it. So anyway, I don't find that persuasive, but you go ahead.
But this is clearly improper because not only did Heller say this, but Bruen emphatically said you cannot engage in interest balancing. You cannot talk about how people can potentially misuse firearms in dictating what kind of Second Amendment rights I get or other Americans get, because we don't measure or restrict constitutional rights by virtue of how they can be misused by some nutjob, psycho, terrorist, crackpot criminal. That's just not how the Constitution works. The Supreme Court has made this over and over and over again. Here's what this is what the U.S. Supreme Court said in Bruen about this kind of interest balancing and why it's totally inappropriate. Heller and McDonald expressly rejected the application of any judge empowering interest balancing inquiry that asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other governmental interests, citing to Heller. We decline to engage in means-end scrutiny because the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon, citing to Heller. This is the Bruen Court, the Supreme Court in Bruen, we then concluded a constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. So that's pretty clear that you cannot talk about things like mass shootings. And by the way, as I pointed out, mass shootings were not unprecedented before the U.S. Supreme Court decided, for example, the Heller case in 2008, because in 2007, there had already been a series of mass shootings, including in 2007, where a nut job in Virginia Tech had used semi-automatic pistols and magazines that held more than 10 rounds to kill many people, unfortunately, at Virginia Tech. That was in 2007. Despite that being discussed and litigated before the U.S. Supreme Court in the Heller case in 2008, the Supreme Court says, we just don't, that's unfortunate, that's terrible, we don't want that to occur, but we're not going to violate some American right because some wackadoodle out there is going to misuse firearms. That's not how we do it. That Supreme Court made that crystal clear, but it seems like Commissioner Johnson wants to go back to interest balancing and say, well, guns can be misused and therefore you and I are subjects, serfs, or peons, and we're not allowed to have guns because some nut job can misuse it. Again, the Supreme Court has repeatedly said that's not how you do it when it comes to applying the Bill of Rights. Now, then the commissioner talks about and tries to basically attack the experts submitted on behalf of Gator's Guns. Now, I'm going to do an entire video about why we should simply not be using experts. They're not necessary in these trials. Nevertheless, let's turn to what Commissioner Johnson says about the experts and Judge Benitez right here.
Yeah, I read that. Yeah, I read the district court's decision in that case, and I have to say. And also I have to say the trial court here, I think, was heavily influenced by some very kind of, questionable, expert testimony, that sort of thing. Ms. Lubinsky, who I think you can't trust at all. There's the other guy, I can't remember his name, something, starts with a K, and they're in all honesty, to be really blunt, they're kind of like in terms of the firearms history, it's almost like a snake oil. They're saying like, that large capacity magazines existed like way before they actually did. They're talking about, repeating firearms existing in the 1500s when, in a practical sense, they didn't. So I'm a little concerned that both the court in California on that Bonta case and the trial court here was heavily influenced by that type of stuff.
Okay, well, this is just absurd for a whole host of reasons, but all I'm going to say is this. There is no need for expert testimony in a Second Amendment case. Ready? There was no expert testimony in Heller. There was no expert testimony in Bruen. There was no expert testimony in Caetano. There was no expert testimony in McDonald. The 4 Supreme Court cases of the 21st century, no expert testimony, and no trial touches fingers with the Second Amendment. All of this is completely unnecessary to assess whether a modern-day gun control law violates the Second Amendment. What's going on here, and I've said this before, I'm going to do it more, is that anti-gun judges, anti-gun courts, anti-gun lawyers and government lawyers are trying to force the Second Amendment community to engage in costly litigation tactics that we would see in a major commercial lawsuit or a major commercial fight on Wall Street. But Second Amendment litigation is not like the types of litigation I would do on Wall Street. They're totally different animals. You do not need to engage in all this heavy-duty discovery. You don't need to engage in all of this expert testimony. In fact, I would say you should never use experts, absent maybe an extreme circumstance we don't need to get into like here or now. But the reason why you should not use experts is exactly what the commissioner said here. And what I mean by that is this. The Second Amendment community wants to proffer these experts to talk about guns and gun history, and they're all fine. But the problem is all you're really doing is you're giving an opportunity for anti-gun judges to whack the credentials and to attack these experts supporting the Second Amendment and to attack them and criticize them and make fun of them and put all this stuff in the court file so they no longer look like experts. So it's a lose-lose. Number one is you don't need Second Amendment experts, because if the Supreme Court in Heller, Caetano, Bruin, and McDonald didn't need experts, you don't need experts in and around America's courts. Below the Supreme Court. The Supreme Court doesn't need experts. The lower courts don't need experts. So just skip it. And if any judge is, and also if you're in front of these anti-gun judges, the experts aren't going to matter. They're going to rule against you, and all they're going to do is take pot shots at your experts. So there's no upside whatsoever, because they're not going to help you win. They're not going to persuade any of these anti-gun judges to do anything good. So don't put them on the spot and get them beat up. It's simply dumb. No upside, in my opinion. Now, I mean, other lawyers can disagree with me. That's perfectly fine. I'm just giving you my opinion on this topic. I think as a general matter, we should not be using these kinds of experts. There is no upside. And then you give commissioners like Michael Johnson the opportunity to take pot shots on the record of the experts proffered in support of the Second Amendment. Even though what they're saying is perfectly fine, that's not the point. It's not going to help when you're in front of these anti-Second Amendment people who are never going to rule for the Second Amendment, no matter, even if Jesus Christ literally stands up and argues in front of these courts. It doesn't matter. They're not going to rule for you. So don't make it worse down the road. Just lose fast, build your record and lose fast and move on. Okay? Anyway, so I hope you learned something here today. We'll see what happens, report on the outcome when the commissioner decides whether or not to continue the stay of Judge Basher's order that had enjoined, for all intents and purposes, or declared unconstitutional, the magazine ban of Washington State. Clearly, this is unconstitutional. If this case gets to the Supreme Court, we're going to win it, but we have to get the U.S. Supreme Court, because I don't think we're going to get any relief in these anti-gun blue state courts where the people are appointed by anti-gun blue state politicians. That's just my opinion. You can disagree with it, but that's what I'm thinking. Don't forget to check out the entire video of the hearing down below in the description. And again, hope you'll learn something here today. Make sure you subscribe to the Four Boxes Diner. Follow me on X at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.